Dear delegates, find your seats. We have all ministers waiting to get their turns as speakers. Please find your seats. Distinguished representatives, I declare open the second plenary meeting this afternoon. We will begin consideration of Agenda Item 7, General Debate. Pursuant to the program of work we adopted this morning, the general debate will continue tomorrow morning and afternoon. States are invited in accordance with Rule 50 of the Rules of Procedure of the Assembly to deliver statements of no longer than 5 minutes. In order to accommodate all speakers, this time limit shall be strictly observed. In order to assist the speakers with the timely delivery of their statements, a light mechanism was installed at the lectern. I would invite delegations to please check the list of speakers dated 1st December 25 at 13 hours 15, available at the conference officer's desk as there have been multiple changes. States were able to submit written or pre-recorded statement in lieu of in-person statements by end of 1st December for posting on the respective webpage of the Assembly. As per concept note distributed by the Secretariat on 23rd October this year, the Assembly will hold a thematic general debate on concrete measures to strengthen the International Criminal Court. We are very pleased to have many ministerial and vice ministerial speakers with us today presenting their national statements. During the ministerial lunch today, we have already held most useful exchange of views and a common understanding of the topics of the thematic debate. At a time when we witness an important erosion of international law and multilateralism, we address questions how we can navigate under political pressure in a way that respects and preserves the judicial independence of the court, who still stands as a symbol and will remain. We discussed the ways how to bear our collective responsibility to shield the court, to protect its personnel, and to ensure that it has the means and support to carry out its mandate in full independence. We expressed our appreciation to the court staff and elected officials for their steadfast dedication to discharging their mandate in an impartial manner. And what more can be done? The answer is multidimensional and involves a combination of political support, legal commitment, and practical mitigating measures aimed at strengthening resilience and autonomy. We considered possible steps for de-escalation while underscoring the outreach and discussions with a partner are not equal to negotiations, nor do they entail any compromise or our common values and principles enshrined in the Rome Statute. But let us now proceed immediately with our first speaker of the general debate. And as the first speaker, we have His Excellency Mr. Gérald Darmanin, Minister of Justice of France.
Madam President of the Assembly of States Parties, Madam President of the Court, Madam and Sir Deputy Prosecutors, Registrar, dear Ministers, ladies and gentlemen. Each year, the Assembly of States Parties of the Rome Statute brings diplomatic and ministerial representatives here on the subject of international law. And this year, 2025, is following the tradition, but it has a particular weight to it. After two deadly world wars and the crimes committed in the 20th century, we could have legitimately thought that cross-boundary legal rules had been solidly set, because history had already revealed such horrors that we could have expected that the international community would never again put up with these crimes against humanity, and that we would certainly never have to have a day come when they could go unpunished and unjudged. We could have imagined that we had a common language and a common set of rules to abide by, and that the worst would be behind us. But none of that took into consideration the major convulsions of these last few months, convulsions that have drastically thrown into question our international legal system, whose vocation was to protect the worst of crimes. This gap that has opened up in the very idea of independent justice and an impartial guarantor of protection of fundamental rights and freedoms. And it's in that context that I've made sure I was here before you today, because France stands ready to reaffirm once again our unwavering commitment to the ICC. France stands in full solidarity with the European statement that shall be pronounced by Denmark later on, whose presence I welcome here. Given this context, the court, the only standing legal jurisdiction with universal vocation, is the cornerstone of a system placed to protect victims of atrocities wherever they occur on any continent. And yet the court is facing an unprecedented time, with these coercive measures that have been leveled at judges and prosecutors, including one French magistrate. They are unacceptable, and I want to express France's firm solidarity with them. The court has also undergone cyber attacks, and France condemns all threats and coercive measures against the court, their staff, or civil society organizations. The absolute respect of its mandate, its independence, and its integrity is an imperative. This collective project that we've built together over more than 20 years needs to be protected together. We're still aiming for universality of the Rome Statute, and France encourages all states parties to stand together around the founding values of the statute with a constructive dialogue among non-states parties. Ladies and gentlemen, the support that France gives is not only political, but also through its long-term concrete actions. France is the third largest contributor to the court's budget. It also has made voluntary contributions, for example, to trust funds, for example, through the IVP's fund, and also is fighting for better geographical representation within the court staff. France has also invested in numerous initiatives, including the way that it co-chairs, along with Senegal, the Working Group on Cooperation under Chapter 9 of the Rome Statute, particularly when it comes to arrests. And finally, with the Crimes Against Humanity section of the National Anti-Terror Prosecution Unit, France is now following through with some 150 proceedings covering some 30-odd geographical regions around the world, including Syria, Ukraine, Israel, Palestine. And this section works closely with the ICC and has lent its support to its sentencing activity. And next year, in 2026, 2 new hearings are about to get underway. Ladies and gentlemen, as we head into the judicial elections in 2026, France encourages states parties to tender candidatures that reflect the diversity of legal systems, diverse languages, and parity between men and women, as well as balanced geographical representation, which bolster the legitimacy of the court. And my words of conclusion will match those of my introduction. Let's go back to the essentials. The fight for justice and against impunity requires courage. And that courage is actually very little that's asked of us when you compare it with the courage of those men and women who are still able to reach out to others at their own peril in areas where there are conflicts that have led to hunger, pain, or blood. We want to welcome the work done by the staff of the court and everything they do to defend these principles, as well as the NGOs who support it. So let us all undertake the same commitment to work together. Let's do it for justice and for the ICC. Thank you very much.
I thank His Excellency for that statement.
Second speaker, Son Excellence Maxime Prévost, Deputy Prime Minister and Minister of Foreign Affairs, European Affairs and Development Cooperation.
Merci.
Thank you, Madam President of the Assembly of States Party. Madam President of the Court, ladies and gentlemen, Deputy Prosecutors, Excellencies, distinguished delegates. I will speak in French, honoring the French-speaking world, speaking in the language of Molière, to state that, first of all, we fully endorse the statement that will be delivered by Denmark on behalf of the European Union and 26 states parties. We fully support it, yet we still have some comments we wish to make in our national capacity. As we all know, the court has gone through a tumultuous year, facing unprecedented challenges. My presence here today as the Deputy Prime Minister speaks for itself. It's a clear message that Belgium reasserts its steadfast, constant, and unequivocal support for the International Criminal Court. Why? Because the court, as an independent and impartial body, is one of the pillars of the international community, a key actor in the fight against impunity, and a driver of international law and justice. These values are values that Belgium will always defend. Let's be honest. Sanctions against the staff and the officers of the court and those that cooperate with them as they carry out their duties are unacceptable. And new institutional sanctions against the court would constitute an unprecedented escalation. Such measures are not simple administrative roadblocks. By targeting those who are working to shed light on truth and assign responsibility, these attacks undermine the rule of law. They hinder the investigations that are underway and deter witnesses and partners from cooperating with the court. They jeopardize the capacity of the court to fulfill its mandate. Indeed, they pose a threat to the international legal order. In a world in which the most heinous crimes require an unchallengeable punishment, is something that is not only deprives us of justice, but it's also something that's very dangerous, because what it does is imposes silence after the violence. Belgium reasserts its willingness to work together with all of the states parties and other partners, of course, in order to support the court and to preserve its independence. I hail the tremendous efforts undertaken by the court to strengthen its resilience and to consolidate its autonomy, its independence, especially in strategic areas such as insurance, bank services, or even IT infrastructure. In light of these sanctions, we also advocate for months now that the general rules limiting the extraterritorial impact of these sanctions on the court. At European level, I maintain that the maintenance of blocking statutes would be an excellent measure. It's a question of principle, but also of protecting international justice. Belgium, moreover, has relations with people in the financial sector in our own country and other services to make sure that Belgium can provide their full support, unconditional support to the ICC. And this creates a climate of trust vis-à-vis the court. We invite all states parties to fully cooperate with the court in concrete terms. Now, on our side, we're doing what we can we have signed the largest number of cooperation agreements with the court, which is a concrete testimony of a long-lasting relationship. Now, we are aware of our obligations as a states party. This is something that applies to us all without discrimination. Cases of non-cooperation undermine the credibility and the effectiveness of the court, and we regret this. In particular, we regret that states have decided to withdraw from the Rome Statute and others are thinking about it. So I would launch an appeal to these governments. In light of the severity of the crimes that continue to be committed and the necessity of impartial justice, I would kindly request that they reconsider their position. Remaining within the Rome Statute system is a common commitment against impunity and in favor of human dignity. We also send out a plea to strengthen the legal framework of the Rome Statute. We call on States Party to ratify all of the amendments that have been adopted in order to consolidate the universality, the consistency, and the effectiveness of the entire system. We are grateful that there is a constructive dialogue on strengthening the competence of the court when it comes to the crime of aggression over the coming years, and we are still extremely open to entertaining other amendments, for example, for slavery crimes or crimes against the environment, without this determining our final position, because international justice has to evolve in order to address the challenges of the world. Dear friends, Belgium shall take every opportunity to reaffirm its support for the court, and we call on all states parties to do the same thing. And despite the challenges, we would like to pay tribute to the resilience of the staff and officers of the court. They continue to fulfill their mission despite the pressure that's been brought to bear upon them. This year, in 2025, has made significant strides in a variety of cases. This hard work, this dedication to justice for the victims reminds us of one thing, and that is our support is essential for them to be strong so that we can restore and make sure that trust in international justice remains. Thank you. Thank you very much.
And the next speaker is Right Honourable Lord Richard Hermer, KC, Attorney General for England and Wales and Advocate General for Northern Ireland.
Madam President, Your Excellencies, distinguished delegates, I welcome this opportunity to address the Assembly on behalf of the Government of the United Kingdom. Madam President, the United Kingdom is a resolute supporter of international law, accountability, and the International Criminal Court. More than 2 decades ago, states took a historic step in creating the International Criminal Court under the Rome Statute. In so doing, we affirmed the principle that the gravest crimes of concern to the international community must not go unpunished. And the court stands as a unique institution in international law, a permanent international criminal court of last resort, seeking justice and accountability for victims. And the UK is proud of its role in the court's inception. Its existence is a beacon of hope for victims and a powerful reminder to perpetrators of the most serious international crimes that they cannot act with impunity. Madam President, the UK commends the progress that the court has made in 2025 in delivering its mandate in the face of unprecedented challenge. And we thank you, Madam President, for your leadership of the Assembly over the past year. The court's successes include securing the first conviction in the court's history for gender persecution as a crime against humanity, marking a hugely important milestone in the effort to tackle and prosecute these crimes against women and girls. This, as well as the arrest warrants issued for 2 Taliban leaders for persecution of women and girls. It's a profoundly important signal that the intolerable suffering experienced in so many conflict zones, yet so often untried in courts of law, will no longer be the case. And this reinforces that at its heart, the International Criminal Court is a court for victims. Since its establishment, over 18,000 victims have participated in cases before the court, and through the Trust Fund, thousands have received reparations and support in places scarred by atrocity. We must continue to safeguard the rights of victims to participate and receive protection, as enshrined in the Rome Statute, and continue to deliver justice on their behalf. Madam President, we congratulate Ukraine on becoming a state party on the 1st of January this year, and we will remain resolute in our support to Ukraine for seeking international justice for the atrocity crimes committed since Russia's illegal invasion. And we regret that 4 state parties have announced their intention to withdraw from the Rome Statute, and we urge them to reconsider. The United Kingdom stands by the principles on which the court was founded, including that of universality. The strength and legitimacy of the court also relies on consensus. And at the special session in New York this summer, we agreed by consensus to consider how to strengthen the court's jurisdiction over the crime of aggression. And the United Kingdom remains committed to engaging constructively with states parties on this issue, recognising the diversity of views on the exercise of that jurisdiction. Madam President, as we approach the court's 25th year, we should be honest that our project faces unprecedented challenges. We should not shirk from finding pragmatic ways to tackle these challenges, and to do so in an open-minded and collaborative manner. The United Kingdom reaffirms its unwavering support for the court's impartiality and independence. We have been clear that we are concerned about the sanctions imposed in connection with the ICC's work and the impact on individuals and the court. And it is incumbent on us all to help the ICC navigate its way through this crisis to ensure that the court remains an effective and sustainable judicial institution. We owe it to the ICC and to those who work tirelessly to deliver its mandate to do so. Engagement and dialogue with non-state parties to understand their views is essential if we are to achieve this. And the United Kingdom encourages all state parties to work constructively in so doing. Madam President, we expect progress and transparency from the court, including on internal oversight. We expect the court to uphold the highest standards by fostering a workplace culture based on integrity and accountability, and by investigating and addressing any and all allegations effectively, seriously, and decisively. Finally, Madam President, the United Kingdom will not waver in our determination to see justice delivered for victims of the gravest crimes, nor in our resolve to end impunity. At this critical juncture, we stand resolute in our support for the court, for its long-term future, for the Rome Statute, and for the principle that justice is a universal duty. Thank you.
Thank you for your statement, and I now give floor to the representative of Nigeria, His Excellency Prince Lateef Olasunkanmi Fakpemi, Attorney General of the Federation and Minister of Justice.
Madam President, on behalf of His Excellency President Bola Ahmed Tinubu, GCFR, I express our profound appreciation to the court and to the Assembly for their tireless efforts in ensuring a successful and meaningful session. I am bringing warm greetings from the Federal Republic of Nigeria. Nigeria's long-standing commitment to the Rome Statute system remains unwavering. Together with the 125 other state parties, we remain united in our collective resolve to hold accountable those responsible for war crimes, genocide, and crime against humanity. Madam President, Nigeria reaffirms its readiness to continue working with the ICC in the fulfillment of its mandate. Our cooperation is firmly rooted in the principle of international law and the sovereign equality of states, and we remain committed to ensuring that such cooperation always reflects respect for Nigeria's sovereignty and constitutional framework. Permit me to highlight some of the recent national efforts aimed at strengthening our commitment to international humanitarian and criminal justice norms. In May this year, Nigeria convened a high-level international humanitarian law dialogue, bringing together relevant ministries, departments, and other agencies and civil society organizations and the academia. This dialogue was part of the ongoing activities to reaffirm Nigeria's commitment to the effective IHL implementation. Nigeria continues to prioritize the protection of civilians and accountability during military operations. Our armed forces conduct operations in line with international humanitarian law and maintain mechanisms for independent and transparent investigations into the alleged violations. The 6-month demobilization, radicalization, and reintegration program, our homegrown initiative, has successfully reintegrated more than 6,000 former combatants into society, contributing significantly to national stability and peace building. Nigeria has also taken important legislative steps, including the domestication of African Union Convention for the Protection and Assistance of Internally Displaced Persons, the Kampala Convention, which now awaits presidential assent. The process for the domestication of the Rome Statute and the additional protocols 1 and 2 to the Geneva Conventions are ongoing. Furthermore, Nigeria has joined like-minded states in the global initiative to garner political support for international humanitarian law and recently endorsed the political declaration on explosive weapons in populated areas. Consequent with the ICC principles of complementarity, Nigeria continues to demonstrate the capability and willingness to investigate and prosecute serious crimes committed within its jurisdiction. In this regard, all arms of our government are collaboratively working to strengthen domestic mechanisms to address grave crimes and reinforce the rule of law. Nigeria, therefore, looks forward to formal conclusion on its situation by the ICC. We will continue to cooperate with the Office of the Prosecutor to address all observations on our situation in line with our international and national obligations. Madam President, the ICC mandate to act where states are unwilling to prosecute the gravest crimes has become even more vital in the face of the alarming increase in armed conflicts worldwide. The disregard for international humanitarian law, deliberate targeting of civilians, and destruction of civilian infrastructure illustrates the urgent need to bolster global accountability efforts. Nigeria particularly finds concerning the dehumanization of wars and armed conflicts against even persons not directly involved in the conflicts. Emerging technologies, including leather autonomous weapons, weapon systems, pose increasingly complex challenge to protection of civilians and attribution of responsibilities. As autonomous systems evolve from defensive tools to potentially offensive weapons, question of legal responsibility and ethical accountability become more pressing. Nigeria, therefore, supports ongoing international processes within the United Nations and other multilateral fora to establish norms, rules, and safeguards that ensure technology serves humanity and not the reverse. We also reiterate our call for the universalization of full implementation of all international humanitarian law instruments. The Assembly must remain attentive to the unique challenges faced by states confronting terrorism, insurgency, conflict, and mass displacement. Nigeria reiterates that global accountability architecture should remain sensitive to these realities, whilst upholding higher standard of justice. Effective cooperation, including victim support, timely sharing of information, technical assistance, and support for international justice system remain essential. Nigeria fully supports efforts aimed at strengthening the ICC independence, efficiency, and credibility. We encourage adequate resourcing of the court and continued implementation of the independent expert review recommendations. We also emphasize the need for continued dialogue between the ICC and the African continent. Africa's peculiar experiences and challenges must be integrated into ongoing discussions on cooperation, complementarity, and reform. Madam President, Nigeria strongly condemns the recent cyber attacks on the ICC digital infrastructure. The attacks are clearly deliberate attempts to undermine the court's independence and mandate and erode global confidence in international justice. We urge the court to deepen collaboration with relevant stakeholders, including experts in the emerging technologies and artificial intelligence, to bolster resistance against future threats and safeguard the integrity of the court's operation. Similarly, Nigeria is concerned about the targeting of officials of the ICC and rejects any action that is capable of undermining the autonomy, independence, and integrity of the court. We urge restraint and dialogue. My delegation extends its warmest congratulations to the newly elected members of the Board of Directors of the Trust Fund for Victims. The fund remains a vital pillar of the Rome Statute system, giving tangible expression to the promise of justice for victims. We trust that the board will continue to discharge its responsibilities with diligence, transparency, and compassion. Nigeria calls for increased voluntary contributions to support reparations and assistance programs that promote integration and healing. Madam President, I conclude by saying Nigeria stands firmly with fellow states parties in the collective efforts to end impunity for the most serious crimes of concern to the international community. We reaffirm our full support for the work of the court and encourage states that have not yet acceded to the Rome Statute to do so in the interest of global peace, justice, and humanity. I want to thank you for your attention.
And I thank you for your statement. Next speaker is Slovenia, Her Excellency Tanja Fajon, Deputy Prime Minister and Minister of Foreign Affairs and European Affairs.
Madam President, Slovenia aligns itself with a statement of the European Union and wishes to convey the following remarks in its national capacity. Madam President, the ICC is a legacy of the Nuremberg Tribunal, whose historic work began 80 years ago. At the time, the Nuremberg Tribunal was novel and experimental. Nevertheless, it applied international law to establish accountability without ambiguity and indecision. It could afford no compromise in addressing the consequences of the worst wrongdoings. The activities of the ICC are not driven by the momentum of victory or fresh enthusiasm. On the contrary, the court builds upon the historic lessons learned and on the development of international law in order to secure global peace and security. It serves the interests of the entire international community, not only state parties. For this reason, it needs and deserves our unequivocal support and protection without hesitation or second thoughts. This institution and the individuals working for it, our citizens, demonstrate daily their dedication to the mandate entrusted to them, independently, impartially, professionally, and with integrity. Any threats, including sanctions and attempts to undermine the independent work of a judicial institution, including those who cooperate with it, constitute an attack on the rule of law, on human rights, and on the stability of the international order based on international law. And strong response of states is needed, and we see triggering the blocking statute as such a measure. The ICC is the world's criminal court, supported by a majority of the international community. It investigates and prosecutes the most senior individuals responsible for the most serious and egregious crimes. Justice matters, and we need it. the victims who are at the heart of the ICC, and all of us who need assurance that such crimes will not go unpunished or recur. Madam President, support comes in many forms. The Court relies on the cooperation of states. We must increase the prospects for executing arrest warrants. The ICC needs sufficient financial resources for its activities across all situations, including those referred by the Security Council. This implies timely and full payment of contributions. Faced with new challenges, including technological developments, the Court must be adequately equipped to address them effectively. We must strive for a resilient and well-equipped Court that will not be easily shaken by external pressures and risks. The Rome Statute gives victims the opportunity to be heard. Court-awarded reparations and assistance programs managed by the Trust Fund for Victims depend on voluntary contributions. And this is a matter of solidarity and willingness to help. Advocating for the universality of the Rome Statute strengthens the foundations for peaceful coexistence. The more ICC is respected, the greater the chance of sustainable peace and security, leading to fewer atrocities and less need for judicial action. Joining cross-regional statements in support of the ICC demonstrates engagement and commitment. Above all, the unity of state parties is a cornerstone of the Court's resilience. Madam President, the establishment of the Nuremberg Tribunal was an example of partnership. Its founders were bound by their respect for the same fundamental values and by their determination to ensure justice. They were prepared to distinguish between what was permissible and what was prohibited, and they acted in good faith. Their constructive search for solutions based on mutual understanding, respect and cooperation was key to achieving their common goal. To succeed in the long term, there can be no room for double standards, transactional policy or selective application of international law. Compliance with judicial decisions strengthens the effectiveness of the international legal system. Slovenia reiterates its unwavering support for the ICC as the keystone of modern international criminal law, a principled and independent judicial institution, and a guarantee of justice for all. Thank you.
I thank you for your statement. And the next speaker is representative of the Kingdom of the Netherlands, His Excellency Arno Rutte, Minister for Legal Protection.
Madam Speaker, dear Excellencies, and dear ladies and gentlemen, we have come together at this 24th Assembly of States Parties in the International City of Peace and Justice, at a time where the Court is needed more than ever. The fight against impunity for international crimes is one that, unfortunately, remains as relevant today as when the negotiations started for the drafting of the Rome Statute. And the Rome Statute has transformed an aspiration into an institution, and since its entry into force in 2002, the number of states parties has more than doubled, an accomplishment that we should all be proud of. And we therefore welcome the entry into force of the statute for Ukraine on the first day of this year. The Court has established itself as an indispensable pillar in the global fight against impunity and is currently investigating situations around the world, from Venezuela to Myanmar and from Ukraine to Darfur. And as the only permanent international court to prosecute the most grievous crimes known to mankind, we must work together to continue the mission we started over 20 years ago, to investigate and prosecute those suspected of these core international crimes at an international level, thereby responding to the legitimate demands of the victims of horrific crimes and preventing further crimes. This year, the Court's judgments on crimes committed in the Central African Republic and Darfur have been important milestones in the fight against impunity for core international crimes. One must only look at the crimes that are currently being committed all across the world to understand the continuing importance of the Court's work in bringing international justice forward. I would like to quote the Court's first president, Philip Kirsch, who stated, "The Court will never be able to end impunity alone. Its success will depend upon the support and commitment of states, international organizations, and civil society." And this statement rings as true today as it did back then. The Court needs the cooperation of all its states parties to carry out its mandate. And at a time where the Court is facing serious challenges, interference, we must stand firmly behind the Court in our joint efforts to protect the international legal order. And as host state of the ICC, the Kingdom of the Netherlands has unique responsibilities and obligations towards the Court. We remain fully committed to fulfilling these obligations, and we work to facilitate the operations of the Court on a daily basis, which involves the work of many dedicated colleagues across ministries. But it's ultimately a shared responsibility of all states parties to ensure that the Court can operate effectively and efficiently. We therefore call upon all states parties to support the Court, from allocating an adequate budget to relocating persons and ensuring the safety and security of ICC personnel present on their territory. At the same time, we encourage all states parties and non-states parties to engage in constructive dialogue on the further shaping of our joint fight against impunity, with full respect for international law. After decades of work to establish the ICC, we must now come together to enable this independent and impartial court to bring justice at a time where conflicts affect millions worldwide. You can count on the unwavering support of the Netherlands, both in its capacity as host state and as a state party, in assisting the ICC in achieving its key objectives. I thank you.
I thank you for your statement. And the next speaker is Representative of Colombia, Her Excellency Rosa Yolanda Villavicencio Mabi, Minister of Foreign Affairs.
Señora Palva.
Dear President Calculanta, President of the ASP, Your Excellency Tomoko Akane, President of the International Criminal Court, Prosecutor Karim Khan, KC, Mr. Osvaldo Zavala-Riled, Registrar of the Court, Excellencies, Judges of the Court, the members of Diplomatic Corps, distinguished representatives of international organizations, and distinguished invited guests here at this 24th session of the Assembly of States Parties of the ICC. It's an honor to take the floor before you to address this assembly here at the 24th session of the Assembly of States Parties of the Rome Statute. I should like to start by reaffirming our firm commitment in the Republic of Colombia to the values that underpin the statute, the Rome Statute. We feel that this is represented in our firm commitment to the independence and the activities of the International Criminal Court, a vital institution for international justice, for the struggle against impunity, and for fomenting peace and stability for all of humanity. The states parties have a duty to defend the activities of the court despite the difficult context, as well as its staff, because when they are under any pressure, interference, or intimidation, then they will not be able to fulfill their role in discharging the court's mandate. Independence means defending international justice, and that is why Colombia wanted to extend its most sincere thanks to the President of the Assembly, President Caucoranta, and to the deputy prosecutors, to all of the teams working at the registrar and in every section of the court for their ongoing efforts despite the external pressure being applied on this institution, which seek to undermine its independence. Similarly, Colombia wishes to reiterate its deepest thanks to the host state, the Kingdom of the Netherlands, for all of the efforts that it has deployed to ensure the protection and adequate operationalism of this institution. We are in a time when multilateralism is under strain. And we want to underscore our firm commitment to bolstering the international system based on rules. In this regard, Colombia would like to call on all member states to reiterate their commitment to these essential basic values of international justice so as to ensure worldwide justice and to respond to today's challenges. Very soon, Colombia will be taking up a seat on the UN Security Council. And when we undertake this responsibility, we are very aware of the need to underscore our commitment to a rules-based international system, defending international law, which is of vital importance if we're going to achieve peace and security around the world. This is actually an opportunity to strengthen the organs of the court, as well as the international relations that enable us to reaffirm the importance of international law and ensure accountability from accountability of perpetrators accused of the most heinous crimes. Colombia continues to underscore the importance and primacy of the International Criminal Court's work as a cornerstone of the battle against these crimes as a court of last resort when national jurisdictions are now unable to prosecute. Madam President, one of the key pillars of this institution is complementarity. And in this regard, the Statute of Rome is based on this model of complementarity and understands the primacy of national legislations to pursue perpetrators of the most heinous crimes perpetrated. And that is why Colombia believes in positive complementarity as a key element in strengthening national efforts to pursue national justice, international justice, and as well as the model of restorative justice, and that can inspire peace, the pursuit of peace through these legal mechanisms. The JEP, in its very first sentences concerning restorative justice, built on these very very fundamentals, and the sentences handed down can serve as an inspiration to other states when it looks to restorative justice after years of conflict in my country. The importance of cooperation cannot be understated between ICC and its states parties. In this regard, Colombia and the OTP have maintained constructive, innovative cooperation, and this dates back to the agreement of 2021 to 2024. By way of an example, we can mention the second work plan between the OTP and the National Jurisdiction for Peace. For Colombia, it is of vital importance that the international justice system keeps its focus on victims. From this perspective, the state of Colombia understands that any attack on the court is actually an attack on the hopes for restorative justice for victims. It's important for them to have an international administration of justice, and because of its specificities, this stands as the last resort for victims to seek justice and reparations. Justice underscores that the court and its organs are going to require the financial wherewithal if it's going to be effective in its pursuit of reparations. And in light of the above mentioned, Colombia values in particular and the sensitive the decisions that have been made that protect the most vulnerable, and welcomes the decisions that have been made in this regard, including victims and witnesses in proceedings. And this has been reflected in the voluntary contribution that the government of Colombia has decided to make to the Trust Fund for Victims. This contribution reflects our firm commitment to international justice and the support for those who have suffered the consequences of the most heinous crimes that are under the jurisdiction of this court. Madam President, by way of conclusion, Colombia wishes to actively participate in various instances created by the Rome Statute. And we feel that this is a way of reaffirming our commitment to the founding values. And my country recognizes the importance of strengthening the independence and impartiality and plurality of the international justice system, which is particularly dedicated, and particular as concerns gender equality and the independence of the court. We have been asked to nominate Coleta Alpalares to nominate her as a candidate for the position upcoming in the court, and we are pleased to announce that her candidature will be developed within the time frame stipulated. Thank you very much.
I thank you for your statement. And next speaker is Representative Uganda, His Excellency Norbert Mao, Minister of Justice and Constitutional Affairs.
The President of the Assembly of State Parties, heads of delegations and representatives of state parties, judges of the International Criminal Court, the Deputy Prosecutor, prosecutors of the International Criminal Court, officers of the International Criminal Court, distinguished ladies and gentlemen. Madam President, on behalf of my delegation, I take this opportunity to congratulate you, Ambassador Paive Kapkoranta, for steering the business of this assembly during this period of unprecedented global turmoil, which has greatly impacted the work of the court. We notably congratulate you for spearheading the management and finding of solutions to navigate against sanctions imposed against elected officials of the court. We also congratulate you for the appointment of a director for our secretariat at the International Criminal Court. I also take the opportunity to congratulate Ms. Gabrielle McIntyre, the newly appointed director of the Assembly of State Parties Secretariat, and welcome her to her inaugural session of the Assembly of State Parties. I wish her the very best in this important role. Madam President, allow me to reiterate Uganda's unwavering commitment to the fight against impunity within her borders and beyond. Our commitment to the fight against impunity is recognized internationally. Our country is situated in a volatile region in Africa, but because of our stability, we are able to host close to 2 million refugees. Uganda is a trailblazer in the strengthening of complementarity. Indeed, the International Crimes Division of our High Court is a model of good practice in Africa. This assembly will recall that in December 2003, Uganda was the first state to make a referral to the International Criminal Court. We have unreservedly worked with the court on the case of Joseph Kony, leader of the Lord's Resistance Army. As of today, we can report that charges against Kony were confirmed in September. We pledge that we shall continue to comply with all our obligations under the Rome Statute. In fact, we shall do more, as we have always done. However, Uganda is unable to fulfill all its obligations without international support. Madam President, we welcome the decision of the Appeals Chamber confirming the reparations order on April 7, 2025 in the Dominic Ongwen reparations case. This decision has raised high expectations among the victims in Uganda. We cannot afford to let down the victims. After all, this court is about justice for victims. We therefore appeal to you, state parties, to increase funding towards the work of the Trust Fund for Victims. Short of that, the reparations order will be meaningless. In a way, the court itself is on trial. This decision is indeed the litmus test to determine whether the court can meet the aspirations of victims of international crimes. We welcome Ukraine and Armenia, who have now ratified the Rome Statute. However, we note with concern the announcement of Hungary, Burkina Faso, Mali, and Niger, who have announced their intention to withdraw from the Rome Statute family. If effected, this would bring the number to 4 states withdrawing within the space of 1 year. This is a serious setback for our drive to universalize the Rome Statute. These developments call for deep soul-searching. Madam President, we have some proposals. Uganda proposes that we revisit Article 87.7 so that we take into account the special circumstances and obligations of any affected state as outlined under Article 98. It is evident that one size does not fit all. We believe that withdrawal does not mean endorsement of impunity. The naming and shaming approach that is currently being employed is not working, and in fact, if continued, would likely lead to more withdrawals. Madam President, as a family, it should be possible for the Assembly to examine each state party's unique situation, its geopolitical circumstances, and the conundrum such states normally find themselves in. Uganda proposes that where complying with the Rome Statute obligations may outweigh national security obligations, the Assembly has a duty to exercise discretion without compromising its principles. Madam President, in the spirit of partnership, Uganda will continue to strengthen cooperation with state parties, civil society, and the appropriate offices of the court and the Rome Statute mechanisms that spearhead work with victims and witnesses and the court as a whole. Uganda is here to stay in the ICC family. That is why we pledge to continue chairing and co-chairing two working groups, namely the Working Group on Complementarity and Gender-Based Crimes and the Working Group on Geographical Representation and Gender Balance. Madam President, in the spirit of our continued engagement with the court, Uganda will put at the disposal of the court its most skilled jurists. Madam President, it's my pleasure to introduce Ms. Rosette Muzigo Morrison, who is Uganda's nominated candidate for election as a judge of the International Criminal Court in 2026. I could not fail to do that because you yourself, Madam President, you have incited us to bring forward candidates. Ms. Muzigo Morrison is an internationally distinguished criminal law expert with 30 years of pioneering practical experience and academic expertise in international criminal law, human rights, and transitional justice. She possesses in-depth knowledge of the legal framework and jurisprudence of the International Criminal Court. She is proficient in addressing sexual and gender-based violence and violence against and affecting children. Ms. Muzigo Morrison served with the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, the Special Court for Sierra Leone, the Independent Commission of Inquiry on Libya, and the International Criminal Court, among other assignments in the course of her illustrious career. Ms. Muzigo Morrison obviously fully meets the criteria set out in Article 36 of the Rome Statute, and given her knowledge and experience, the government of Uganda is confident that she is an excellent candidate to serve as a judge at the International Criminal Court. She will significantly contribute to its efficient and effective operation if elected. Who wouldn't want such a person on the bench of the International Criminal Court? Please vote for her. Madam President, allow me to conclude by reiterating Uganda's continued support for the court. We believe in this court. That's why we were the first country to refer a case to the International Criminal Court. And even if everyone left, we will still be around. Madam President, we wish you and everyone here great deliberations for the coming week. For God and my country. Thank you very much.
I thank you for your statement. And next speaker is from Sierra Leone, His Excellency Alpha Sesi, Attorney General, Ministry of Justice.
Madam President, Excellencies, distinguished delegates, good afternoon. Sierra Leone welcomes the timely theme for this general debate and the call for concrete measures to strengthen the International Criminal Court at this defining moment for the Rome Statute system. This is therefore not a routine assembly. It is a test of our collective resolve. Over the past year, the only permanent International Criminal Court has faced coordinated attempts to undermine its authority. Sanctions have been imposed on 9 elected officials for doing nothing more than carrying out their mandate. A sophisticated cyber attack has sought to infiltrate the court systems and disrupt its operations. These acts strike at the heart of the Rome Statute system and at the principle of judicial independence on which international criminal justice rests. Yet, despite these pressures, the court has continued to investigate, to hold trials, to deliver judgments, and to advance reparations. This resilience shows both the courage of its officials and the enduring truth of the Rome Statute vision that no one is above the law and that justice for the most serious crimes is indispensable to lasting peace. Sierra Leone therefore reaffirms its unwavering commitment to the court and to the principles of universality and integrity enshrined in the Rome Statute. Our own experience has taught us that peace without justice is fragile, and that accountability for serious crimes is the surest safeguard for stability. Sierra Leone therefore remains committed to defending the court's integrity, promoting the values of the Rome Statute system, and advancing the cause of justice as an indispensable pillar of the international peace and security. Madam President, in the face of threats and coercive measures, the court's credibility now depends on concrete and sustained actions by state parties. The Assembly must move from expressions of concerns to practical measures. In Sierra Leone's view, 4 areas of commitment are particularly urgent. First, we must protect the independence, the security, and the integrity of the court. The sanctions imposed on the court's elected officials are unacceptable and incompatible with international law. They must not become the new normal. The Assembly should take a further step by reinforcing the mechanism for collective response to such attacks. Those developed following the independent expert review and the review mechanism to implement Recommendation 169, combining diplomatic, operational, and, where appropriate, legal measures. Enhance cybersecurity cooperation with the host state and other partners, together with strengthened security and support for the court officials, staff, and those who cooperate with the court, should form part of a broader resilience package. If we do not protect those who deliver justice, we weaken justice itself. Second, cooperation and complementarity must be deepened. 33 arrest warrants remain outstanding. Each unexecuted warrant represents an open wound for victims and a gap in our promise to fight impunity. Sierra Leone calls upon state parties to fulfill their legal obligations. That is to execute warrants, facilitate investigations, and enforce sentences and reparations orders. On complementarity, we support the Office of the Prosecutor and other organs of the court engaged in capacity building in consenting countries, so that strong national systems can shoulder their primary responsibility to investigate and prosecute Rome Statute crimes. Third, universality and equality of justice must be reinforced. The legitimacy of the court rests on its reach and on the equal application of the law. Sierra Leone welcomes Ukraine's ratification of the Rome Statute. We urge all states that have not yet done so to ratify the statute and the relevant amendments, including those on the crime of aggression. We regret withdrawals and notifications of withdrawal, and we appeal to those states to reconsider. Fourth, victims must remain at the center, and the trust fund for victims must be sustainably financed. Victims are the moral core of the Rome Statute system. Their participation gives meaning to our work. Supporting victims is not an optional extra. It is justice delivered in full. We therefore urge all state parties to provide predictable and sustained resources for the trust fund's dual mandates of assistance and reparations, and to build stronger partnerships between the trust fund, relevant international agencies, and national authorities so that victims' rehabilitation is integrated into broader development and recovery frameworks. Let me close, Madam President, by reiterating Sierra Leone's firm belief that international criminal justice is a cornerstone of international peace and the rule of law. At this critical moment, neutrality in the face of attacks on the court is not an option. We must stand with the ICC, advocate for universality, promote cooperation, and support the Trust Fund for Victims. By acting with unity and urgency today, we honor the promise made in Rome in 1998 that future generations shall not continue to suffer the scourge of atrocity crimes with impunity. On that note, I thank you, Madam President, and ladies and gentlemen. Thank you.
I thank you for your remarks, and the next speaker is Ghana, His Excellency Dominic Akuri-Dinginga Ayen, Attorney General and Minister of Justice. You have the floor.
Madam President, Your Excellencies, distinguished delegates, I convey Ghana's appreciation to Her Excellency, Madam Ambassador Paivi Kokoranta, I hope I got that right, and the Bureau for the sterling leadership they have provided state parties during her tenure and throughout the year for the diligent work done in guiding the proceedings of the 24th session of the Assembly of State Parties to the Rome Statute. I assure you, ladies and gentlemen, of the full support of my delegation for a successful conference. My appreciation also goes to the President of the Court, Judge Tomoko Akani, and to the Secretariat for the excellent work done in the management of the affairs of the Court. Madam President, Ghana reaffirms its firm commitment to the Rome Statute system and to a rules-based international order founded on accountability, justice, and respect for human dignity. For over 2 decades, the Court has contributed significantly to combating impunity and delivering justice for victims of the gravest crimes of international concern. Yet, today's global environment presents increasingly complex threats to the maintenance of international peace and security. Widespread conflicts, flagrant violations of international humanitarian law, and sophisticated attempts to evade accountability underscore the importance of reinforcing the Court and ensuring its continued relevance and its effectiveness. In this regard, Ghana welcomes the theme of this year's Assembly of State Parties, that is, concrete measures to strengthen the International Criminal Court. Strengthening the court requires not only principled support, but also the adoption of practical and actionable measures to enhance its operations, fortify its independence, and secure its ability to deliver justice. Against this backdrop, 27 years after the adoption of the Rome Statute, Ghana remains firmly convinced that universality is essential to credible, impartial, and effective system of international criminal justice. In this regard, Ghana warmly welcomes Ukraine as the 125th state party following the entry into force of the Statute for Ukraine on January 1st, 2025. Madam President, at the regional level, concerning Africa and the ICC, Ghana continues to advocate for dialogue and engagement in addressing the challenges the court is confronted with, particularly the strengthening of relations between the court and African states. We call for more of such complementarity initiatives of the court and effective partnerships with local authorities in enhancing the capacity of national jurisdictions to deal with the most serious crimes of concern to the international community. Ghana holds the view that the best form of support for the ICC is by African nations consolidating democracy in their jurisdictions and avoiding conditions suggestive of impunity, calling for the intervention of the ICC. When democracy reigns and is practiced in its true form, with the citizens feeling a sense of fulfillment of the entitlements of citizenship, free expression, security, adherence to constitutionality, for governments without an attempt to manipulate same, concerns about the commission of genocide, war crimes, crimes against humanity, and impunity in general will be non-existent. Conditions which attract the interest of the ICC will necessarily be eliminated. Further, the pure practice of democracy in Africa enjoins the establishment of sound systems of justice and the creation of facilities for the investigation and trial of cases of interest to the ICC. This, without doubt, is in line with the declared objective of the ICC as it fosters the principle of complementarity enshrined in the Rome Statute. We commend the court and the state parties for their collaborative efforts in deepening cooperation and complementarity in favor of justice for the victims of atrocities. My delegation affirms the need for effective operationalization of the principle of complementarity in furtherance of the full realization of the objective of the framers of the Rome Statute at the national level. The primacy of national jurisdictions over the prosecution of crime requires the occurrence of two things. First, all states must have strong and effective legal and judicial systems for investigating and prosecuting international crimes as the ICC itself. As the ICC itself lacks the capacity to investigate and prosecute all international crimes committed in the territories of its member states. Second, domestic legislation of African countries must recognize war crimes, crimes against humanity, and genocide as specific offenses. This may be achieved either through the domestication of the Rome Statute into our laws so that national courts assume jurisdiction over offenses created by the Rome Statute, or the passage of a specific legislation affirming the creation of such offenses with punishment duly prescribed according to international standards and a forum for punishment of same within our respective domestic legal jurisdictions duly stipulated. Madam President, beyond the African continent, Ghana welcomes the cost-expanding engagement in situations across different regions of the world, including the opening of new situations by the Office of the Prosecutor and the strengthening of its field presence abroad. These developments affirm the universal nature of the Rome Statute and reinforce the confidence in the court's impartiality. They also help dispel the perception that the court unduly concentrates on Africa, especially as international crimes under the statute know geographical boundaries. The court must also be able to act wherever its jurisdiction is engaged and to respond without equivocation to war crimes, genocide, crimes against humanity, and the crime of aggression committed anywhere in the world. Madam President, distinguished delegates, my delegation is deeply concerned about the increasing attacks, threats, and sanctions or measures of a similar effect directed at officials of the court, United Nations mandate holders, and civil society actors cooperating with the court. Such sanctions undermine judicial independence and pose a direct threat to the global fight against impunity. We are further alarmed by the malicious cyber attack that sought to infiltrate the court's information systems and disrupt its operations, reflecting the evolving nature of attempts to obstruct international justice. These developments highlight the urgent need to fortify the court's digital infrastructure, enhance the protection of its personnel and partners, and strengthen cooperation with the host states and other jurisdictions in responding to retaliatory measures. Ghana affirms that no form of political, financial, or technological intimidation should be permitted to impede the independent and impartial functioning of the court. We call for unified and unequivocal support for the court and the lifting of all measures that hinder its work or target its officials. My delegation also wishes to stress the importance of ensuring fairness and equity in the recruitment of staff of the court as wide geographical and gender balance basis as possible based upon the highest standards of efficiency, competence, and integrity. This will no doubt give equal opportunity to competent nationals of all state parties to bring their varied experience and perspectives to bear at the court to enhance institutional efficiency whilst ensuring impartiality in the workings of the court. Ghana welcomes the outcome of the 2025 special session on the review of the Kampala amendments held in New York. We commend the Bureau, the dedicated working group on amendments, and civil society for their extensive and inclusive preparatory work. Ghana supports the continued strengthening of the court's jurisdiction over the crime of aggression and encourages state parties to ratify or accept the relevant amendments. In conclusion, Madam President, by expressing my delegation's profound appreciation to the government and people of the Royal Kingdom of the Netherlands for their continued support in hosting the court in The Hague. I thank you all for your attention.
I thank you for your remarks. And the next speaker is Botswana, His Excellency Ramatwana Nelson Ramatwana, Minister of Justice and Correctional Affairs.
Thank you, Madam President and other justices present. Excellencies, distinguished delegates, on behalf of the delegation of the Republic of Botswana, I am honored to address this esteemed Assembly at its 24th session of the state parties to the Rome Statutes. I bring a delegation of senior government officials, no less the person of Her Excellency Ambassador, Permanent Secretary in the Ministry of Justice and Correctional Services, National Police Commissioner, National Prison Commissioner, and Director of Directorate of Public Prosecution, Madam President, to show that we indeed honor this honorable court. The government of the Republic of Botswana commends the International Criminal Court for its pivotal role in upholding international justice and combating impunity for genocide, crimes against humanity, war crimes, and the crime of aggression. As a proud state party, Botswana reaffirms its commitment to supporting the court's mandate and advancing accountability, reinforcing the principle of peace, human rights, and the rule of law. The principles enshrined in the Rome Statute remain as relevant today as ever, particularly in a global environment marked by conflict, human rights violations, and challenges to the rule of law. Madam President, Botswana is deeply concerned by the threats, attacks, and undue political pressure and recent sanctions directed at the court and its personnel. These measures include asset freezing and travel bans on the judges and prosecutors represent a serious challenge to the court's independence and impartiality. The international community must unite to defend the integrity of the ICC, ensuring its officials can perform their judicial duties free from coercion, harassment, or intimidation. Any alleged cyber attacks and other attempts to undermine the court's work only further jeopardize its credibility and effectiveness. Madam President, Botswana attaches great importance to the legal framework underpinning international criminal justice. The government of Botswana ratified the Rome Statute in September 2000 and the Kampala Amendments in April 2013. Over the years, we have progressively domesticated the statutes through national legislation, culminating in the enactment of the Serious Crimes of International Concern Act in August 2023 by the government of Botswana through the legislature. This act criminalizes genocide, crimes against humanity, war crimes, and the crime of aggression. It removes statutory limitations for such offenses and provides for cooperation with the court, including hosting, investigation, and enforcement of sentences. The Act aligns Botswana's laws with international standards, extending the Extradition Act and Mutual Legal Assistance in Criminal Matters Act to the ICC. This enables joint investigations, information sharing, and the surrender of accused persons while upholding the principle of complementarity. The legislation further provides for full cooperation with the ICC, including court sittings in Botswana, enforcement of its orders and sentences, the serving of custodial sentences locally, and recognition of the court's legal personality and judicial privileges. Madam President, with this legal framework in place, Botswana is ready to strengthen accountability for crimes of international concern and to reaffirm our unwavering commitment to justice, human rights, and the rule of law, both nationally and internationally. I wish to underscore that Botswana is committed to building the national capacity required to investigate and prosecute international crimes. We therefore seek targeted partnerships, technical assistance, and knowledge exchanges to strengthen complementarity and ensure that no crime of international concern goes unpunished. Madam President, this 24th session of the Assembly addresses several critical issues central to the effective function of the court. Botswana therefore wishes to highlight the following. On financial resources, Botswana underscores the urgency of reviewing and adopting the 2026 budget to ensure that the court can continue to implement its mandate effectively in light of the current economic challenges. Adequate funding is indispensable for the court to carry out its judicial, investigative, and outreach responsibility, which are vital to the cause of international justice. On response to non-cooperation, we recognize the importance of addressing instances of non-cooperation, including political attacks and coercive measures, targeting the court and its officials. Botswana reiterates that upholding principle of the Rome Statute and defending the court's independence, integrity, and credibility remains a shared responsibility of all state parties. On the review of the crime of aggression, Botswana welcomes the mandated review of the Kampala Amendments concerning the crime of aggression. We encourage all state parties to engage constructively in this process, and it is essential for maintaining the integrity and relevance of the Rome Statute framework. Budgetary and financial matters, we note the importance of reviewing reports on contribution as well as the activities of subsidiary bodies, including the boards of director of Trust Fund for Victims, to ensure full transparency and effectiveness in all operations. We remain committed to supporting the court in fulfilling its vital mandate and reaffirm our dedication to the principles of justice, accountability, and international cooperation, which are the pillars of the Rome Statute system. Botswana reiterates that for the statute to deliver justice universally, each state party must actively support the court financially, operationally, and politically. Only through our collective commitment can we strengthen the international criminal justice system and safeguard accountability for the gravest crimes of concern. In conclusion, the government of Botswana reaffirms its unwavering commitment to the Rome Statutes and the International Criminal Court and pledges to continue cooperating fully to advance justice, accountability, and the rule of law. Botswana, which is at the center of the Southern Africa, surrounded by Zimbabwe on the north, Mozambique on the northeastern part of Botswana, South Africa on the south, and Namibia and Zambia on the west. We bring nothing but peace. We are a doyen of peace and democracy. And Botswana, we believe in the integrity and legitimacy of court. And in Botswana, we believe also in dialogue. Where there are disputes, whether with our opponents, we engage in dialogue. Hence, in Botswana, we have never had civil war. And last year, an opposing party that was in opposition for 58 years took power, and the ruling party that was in power for 58 years. We work together as if we belong to one party because we believe in dialogue, we believe in peace. And we can benchmark with Botswana when it comes to the notion of peace. With that, Madam President, I thank you for your attention. Thank you.
Thank you for your statement, and I will now give floor to Madagascar, Her Excellency Fanny Rizzoa Ernaivo Garde de Sul, Minister of Justice.
Madam President of the Assembly of States Parties, Madam President of the International Criminal Court, ladies and gentlemen, members and representatives of states parties and also of the International Criminal Court. Good afternoon. Madagascar wishes, first of all, to express its steadfast support to the International Criminal Court, to its prosecutor and to its judges, to all of its staff. The court is currently in a context where there are multiple attacks against it. This is unprecedented. Madagascar and the government that I represent here today reaffirm our enduring support for the International Criminal Court and to the principle that international criminal justice is a non-negotiable. Any attack against the court is an attack against the victims and grants impunity to those responsible for such crimes. If Madagascar shares these views today, it's because our own country has come out of a very long and painful process that lasted 16 years from 2009 to 2025. And during this time, institutions were thwarted, sovereignty was confiscated, and public resources were channeled into an economic policy that was something that wasn't just an abuse of power, it was a total privatization of the state. It was a period of economic predation, and everything was done just to serve the private interests of a small clutch of individuals. And the consequences were just on a par with any crime of genocide or crimes against humanity. During this past 16 years, public services have collapsed, and Madagascar is now the fifth poorest country in the world, despite all of our riches. And this is why we wish to announce that we would propose to the ICC a new criminal offense, which would be state capture. That's what's happened in our country. We are willing to cooperate with others to establish this form of crime so that any other country that has been victimized by this would experience the same thing that we have. And at the same time, we also support the technical, political, and legislative efforts of the ICC to make sure that justice can be served in our country and in all other countries around the world who are suffering from this. At the same time, we can also propose judges, technical experts, and we are willing to cooperate in coming up with proposals in order to establish this international crime alongside the other crimes that the ICC has competence over. We are currently proposing the nomination of our financial judge for the CBF of the ICC, and apparently Burkina Faso has also presented a candidate but has withdrawn their candidate. That's my understanding. So we only have one candidate remaining. Thank you very much.
Thank you for your statement. And next speaker is Denmark on behalf of the European Union. Her Excellency Elisabeth Sondergaard Krone, Vice Minister, Ministry of Foreign Affairs.
Madam President, I'm honored to address the Assembly of States Parties on behalf of the European Union and the following EU member states: Austria, Belgium, Bulgaria, Croatia, Cyprus, Czechia, Estonia, Finland, France, Germany, Greece, Ireland, Italy, Latvia, Lithuania, Luxembourg, Malta, Netherlands, Poland, Portugal, Romania, Slovakia, Slovenia, Spain, Sweden, and my own country, Denmark. The following states also align themselves with this statement: Andorra, Bosnia-Herzegovina, Georgia, Republic of Moldova, Montenegro, North Macedonia, Norway, San Marino, and Ukraine. In this capacity, I would like to commend the President of the Assembly, the President of the Court, as well as all other elected officials for their work and dedication, and assure them of our steadfast support. The ICC is the cornerstone of the international fight against impunity, holding perpetrators of the world's gravest crimes accountable and bringing justice to victims. The EU stands firm in defense of the court in the face of threats and sanctions against the court, its elected officials, and those cooperating with the court. We therefore welcome this year's special focus of our general debate. The cyber attacks and sanctions are concerning, and they affect the functioning of the court and impair its capacity to deliver justice to victims. They also have an effect on civil society actors who work to support the court and assist victims. The EU has engaged directly with the court and affected officials, as well as with civil society actors, to discuss the current situation and will continue to explore concrete measures which can help to protect the court and increase its resilience. The ICC is working with determination to deliver justice and must be able to pursue its independent investigations and impartial judicial proceedings across all situations. In line with this, and with full respect for international law, we encourage all states parties and non-state parties to engage in constructive dialogue on strengthening the fight against impunity. In this regard, we also call on all states parties to live up to their obligations and refrain from any action that would frustrate the activities of the court or undermine its decisions. We note that a lack of cooperation may affect the court's ability to carry out its responsibilities. We call on all states parties to redouble efforts to identify new avenues for strengthened cooperation with the court, and thank all of you who are already doing so. We commend the work of the court over the past year, particularly at a time of increased workload and a challenging operational environment. The recent conviction of the Darfur situation is a first in many respects. Finally, delivering justice for some of the many victims in Darfur, reaffirming gender-based persecution as a crime against humanity, and implementing the referral to the ICC by the UN Security Council. We are mindful that the court needs adequate capacities commensurate with the increasing workload and challenges to its work. We therefore call on all states parties to provide the ICC with the necessary financial resources and diplomatic support. We thank the Committee on Budget and Finance for its thorough work and welcome its recommendation regarding this year's budget. The EU is ready to do its part, including through the provision of grants and other necessary assistance to ensure the court's effectiveness. Is the sound still on? Yes, now it's back. Was that the 5 minutes? Another way of supporting the court and the Rome Statute system is to aid efforts strengthening national capacities to deal with the most serious international crimes. Both the EU Council decision on the ICC and the relevant action plan highlight the importance of implementation of the principle of complementarity. We thus welcome the work of the court and the Office of the Prosecutor in this regard, including under the Trust Fund for Complementarity. We encourage the ICC and states parties to continue working on the implementation of the recommendations stemming from the review by the independent experts, including on recruitment procedures, as well as a healthy work culture that ensures inclusion, geographical representation, and gender equality. Allegations of misconduct against ICC officials must be thoroughly investigated and addressed in a transparent and expeditious manner. Our position is clear. There must be zero tolerance for misconduct, irrespective of rank. At the heart of all efforts in pursuit of truth, justice, and accountability stand the victims and survivors. The EU also calls on states parties to contribute to the Trust Fund for Victims, as it plays an essential role in ensuring that thousands of victims receive reparations and assistance. We also urge all states to support and protect human rights defenders and civil society organizations who work to bring justice to victims. Madam President, to succeed in the global fight against impunity, the ICC must become truly universal. The EU will continue encouraging the widest possible participation in the Rome Statute and its effective implementation at the national levels, as well as in the agreement on the privileges and immunities of the ICC. We congratulate Ukraine on becoming the 125th state party of the Rome Statute as of this year and encourage Ukraine to ensure its swift implementation. At the same time, we regret the recent announcement by some states parties on their decision to withdraw from the Rome Statute and encourage them to engage in dialogue with the court, the Assembly, the regional organizations, and civil society. The EU further invites states parties, having considered the national circumstances, to ratify or accept the Rome Statute's amendments and the agreement on the privileges and immunities of the ICC. We recall in this context the successful special session on the review of the amendments on the crime of aggression, which adopted a consensus-based decision on a constructive way forward on this topic. Madam President, the EU will continue calling for the perpetrators of the most serious crimes to be brought to justice and held accountable. No one, no matter who they are or where they are, must be allowed to escape justice, which must be delivered to every victim. Thank you.
I thank you for your statement and give floor to Czech Republic, His Excellency Jiří Slejs, Director General of the Legal and Consular Section, Minister of Foreign Affairs.
Madam President, Your Excellencies, distinguished delegates, the Czech Republic fully aligns itself with the statement just delivered by Denmark on behalf of the European Union and its 26 member states. In my national capacity, I would like to add a few remarks. At the outset, the Czech Republic wishes to commend you, Madam President, for your leadership in these challenging times, as well as the ASP Secretariat and the entire team for the excellent preparation of this ASP. The challenging times advocate for a strong commitment. As such, the Czech Republic endorses the declaration of the ASP to be adopted at this session, which reminds us of our responsibility to support the court and rejects any attempts to undermine its independence. At the same time, it recognizes the need for a dialogue with non-state parties in full respect for international law. The fight against impunity is a common goal. The fact that the court is a well-established, independent, and efficient judicial institution is best illustrated by its workload and by the wide participation of states in the Rome Statute system. In this regard, we join you, Madam President, in welcoming Ukraine as the most recent state party as of the 1st of January this year. Madam President, this ASP session is the second one taking place this year. Let me briefly reflect on the outcome of the special session which took place this July in New York. In the respective resolution, which the ASP consensually adopted, it committed itself to the aim of strengthening the jurisdiction of the court over the crime of aggression. We are ready to engage in good faith to overcome the continuous jurisdictional gap. Currently, in spite of the limited protection the Kampala amendments offer to those state parties who ratified them, they continue to be the most widely ratified amendments. Let me welcome the acceptance or ratification of the said amendments as of this year by Denmark, Seychelles, and Timor-Leste. Madam President, the Rome Statute requires the elected officials to be persons of high moral character. Their outstanding professionalism in performing duties is a must. This is disconnected with any behavior of misconduct which needs to be, in all cases, properly investigated and dealt with by the competent decision makers. We hope that the permanent mechanism to solve cases of misconduct of elected officials as to be adopted by this SAP will contribute to improvements in the workplace culture. Madam President, last but not least, I wish to recall the important work of the Trust Fund for Victims, which the Czech Republic is proud to financially support since 2011. We praise the excellent work of its executive director and her team, conducted both in the reparation and assistance mandates. Thank you, Madam President.
I thank you for your statement and give forward to Norway His Excellency Andreas Motzfeldt Gravik, State Secretary and Deputy Minister of Foreign Affairs.
Madam President, on 17th of July 1998, the world witnessed a defining moment in the history of international law. The adoption of the Rome Statute was not just a legal achievement, it was a powerful statement of our shared determination to end impunity for the most serious crimes. It was based on a common understanding that impunity for grave crimes threatens peace, threatens our security, and threatens the well-being of humanity. This year, we gather at a time of heightened global tensions. The world is more divided, more dangerous, and more unpredictable than it has been for decades. Respect for international law is eroding. Institutions built to uphold the legal order are under pressure. Civilians in many parts of the world are subjected to grave violations of international law, living in devastation, without protection, and denied justice. At this critical juncture, the need for the ICC is greater than ever before. As an independent institution with a global mandate, the ICC plays a vital role in holding perpetrators accountable. Its work is guided by the principles enshrined in the statute, ensuring fairness, due process, and respect for international law. Madam President, this year has been particularly challenging for the ICC. The court has faced renewed cyber attacks, and several of its elected officials, as well as individuals and organizations cooperating with the court, have been targeted by sanctions. Such measures are deeply troubling and set a dangerous precedent. Targeting individuals for performing their legally mandated duties undermine the integrity of international justice, which has long served the global community with purpose and principle. These actions undermine trust in the international legal order and send a chilling message to those who seek to enforce accountability for the gravest crimes. The ICC was established to serve as a court of last resort, free from political interference and guided solely by legal principles. In the face of these challenges, it is imperative that we stand firmly in defense of the court's independence. The credibility of the international justice system depends on our collective ability and resolve to protect it from undue pressure and retaliation. Norway remains unequivocal in its support for the ICC and urges all states to refrain from measures that could compromise the court's ability to fulfill its mandate and to reaffirm their shared commitment to the principles of international law. Despite the pressures it has faced, the court has shown resilience and a steadfast commitment to judicial duties. The court has made notable progress, advancing investigations, issuing arrest warrants in multiple situations, and reaching key milestones in trials and convictions. These achievements underscore the court's growing relevance. Reliable funding is essential to safeguard the court's independence and ensure it can withstand political pressure. Norway calls on all state parties to ensure the court has the resources it needs to carry out its mandate and to agree on measures that strengthen the court's financial resilience, ensuring operational continuity in situations of external pressures. Like all institutions, the ICC must continuously strive for improvement. Progress has been made to enhance court operations, guided by the recommendations of the independent expert review. Although the mandate of the review mechanism has concluded, the implementation of recommendations must continue. Norway will remain engaged and will closely follow efforts to strengthen the court's workplace culture, recognizing that a healthy environment is essential to the effective fulfillment of the review mandate. Madam President, Norway deeply regrets the withdrawal of Hungary from the court. We are also concerned by the recent announcement of Burkina Faso, Mali, and Niger regarding their intention to withdraw from the statute. We urge these states to reconsider. Concerns should be addressed through constructive dialogue in a manner that respects the integrity of the court. At the same time, we are encouraged by new accessions to the statute. The growing membership of the court strengthens the global architecture of legal protection against the most serious international crimes. In this regard, we welcome Ukraine as the 125th state party from 1st January this year, a powerful statement to our shared commitment to the ICC's foundational principles. However, universality is not enough. The court's ability to deliver justice depends on the full and effective cooperation of its states parties. We urge all states to meet their obligations under the statute by enabling access, sharing evidence, and executing arrest warrants without delay. Selective cooperation and double standards must be firmly rejected. This is a shared responsibility, and Norway remains fully committed to doing its part. Madam President, let us not lose sight of the aspirations that guided us in 1998 when the ICC was established. For survivors of atrocity crimes, international justice is not merely a concept, it is a lifeline, a thread of hope, and the first step on a long journey towards healing and peace. It's our collective responsibility to safeguard and strengthen the Rome Statute system, a landmark achievement born of global cooperation and shared vision. And I thank you.
I thank you for your remarks, and I will now give the floor to Estonia, Her Excellency Kerli Veski, Vice Minister, Undersecretary for Legal and Consular Affairs.
Madam President, distinguished delegates, Estonia aligns itself with the statement delivered by the European Union. The International Criminal Court remains a cornerstone of the rules-based international order, playing a vital role in the global fight against impunity over the most serious international crimes that threaten the peace, security, and well-being of the world. Estonia reaffirms its unwavering support to the ICC and the principles of the Rome Statute. We commend the ICC for its continued work to uphold justice under current challenging circumstances, from increasing caseloads to unprecedented threats and sanctions targeting its judges and officials. Despite these difficulties, the ICC remains steadfast, impartial, and independent in carrying out its judicial mandate. We express our concern at the imposition of sanctions and coercive measures against the ICC. The ICC must remain shielded from political pressure. We call upon all states, whether parties or not, to respect and protect the court's independence against any coercive actions and sanctions, and to ensure that the ICC can fulfill its mandate without fear of interference. This is our collective duty. Estonia is concerned about continued cyber attacks against the ICC. We commend the ICC for having conducted a comprehensive threat assessment of its information and communication technology security infrastructure, and for developing a new security blueprint for its cybersecurity architecture. We also warmly welcome recent adoption of the policy paper on cyber-enabled crimes under the Rome Statute, the result of a good international cooperation, which Estonia has supported throughout the project. It provides clear guidance to the Office of the Prosecutor for investigating and prosecuting cyber-enabled crimes under jurisdiction of the ICC, and enables support to national efforts to address misuse of cyberspace under applicable national law while ensuring adherence to international law. Madam President, the integrity of the Rome Statute system depends on cooperation with states parties, in particular in implementing arrests and surrenders, as non-compliance prevents the ICC from exercising its functions. More than 30 arrest warrants remain unimplemented. We regret that this year again we have seen incidents of non-compliance. We call on all states to fulfill their obligations to execute arrest warrants, surrender suspects, and refrain from any contacts with persons subject to ICC arrest warrants. We cannot ignore the grave situation unfolding in Ukraine. We invite the ICC to pay continued attention to the investigation of the situation in Ukraine. The arrest warrants, including in respect of Russian leadership, send a clear message that no one, regardless of rank or position, is above the law. Estonia welcomes steps taken in the Council of Europe to establish the Special Tribunal for the crime of aggression against Ukraine. Now further steps should follow to make the Special Tribunal operational as soon as possible. The international community should continue our steadfast support to Ukraine in the fight against impunity. The Special Tribunal complements the work of the ICC, which currently has limited jurisdiction over the crime of aggression. As during the special session this July, states parties were unable to fully address this legal gap. It is important to continue efforts to build consensus towards harmonizing the court's jurisdiction. Estonia commends the Trust Fund for Victims for its invaluable work in rehabilitation, recovery, and empowerment of victims and their communities. For many years, Estonia has been a regular donor of the Trust Fund, and we repeat our call for all states and other stakeholders to support the Trust Fund as it embodies the humanitarian and moral heart of the Rome Statute system. Estonia calls upon all states to pay their assessed contributions in full and on time. Madam President, Estonia congratulates Ukraine for becoming the 125th state party this year, and we call upon all states that have not yet done so to ratify the Rome Statute and its amendments. At the same time, we regret that some states have made public statements about their withdrawal from the Rome Statute. We encourage these states to review their position and remain states parties to the Rome Statute. The ICC embodies the collective concerns of humanity. It stands for the idea that even in the darkest moments, justice must prevail. It stands for the rights of victims, the dignity of human beings, and the belief that peace is built on accountability, not impunity. Thank you.
I thank you for your statement and give floor to Switzerland. His Excellency Franz Perez, State Secretary, Director General, Directorate of International Law at the Federal Department of Foreign Affairs.
Thank you very much. Madame la Présidente.
Madam President, dear ministers, excellencies, dear colleagues, the International Criminal Court is a necessity more than ever today. And we, first of all, would like to reiterate our commitment to the ICC. As a state party, it's our responsibility to support the ICC while respecting its full independence, impartiality, and integrity. And it's because of these three I's that we are proud to recommit to supporting the ICC and ensure its survival. The court will only be resilient if we, states parties, are also resilient. The ICC benefits one and all. It is the cornerstone of the struggle against the impunity when it comes to the commission of the most heinous crimes, and it bolsters international law. It gives a voice to victims, and yet the ICC and its staff are facing unprecedented challenges, even though they are only doing their noble duty that we, as states parties, have entrusted them with. But the court will only be able to fulfill its mandate effectively if its founding principles in the Rome Statute are respected. Madam President, Excellencies, ladies and gentlemen, we need to, as a united front, support the ICC to make it more resilient. Switzerland is impressed by the way that the court is resisting these outside pressures, and we want to thank each and every one of you for your impressive work when it comes to building resilience and ensuring efficacy, effectiveness, impartiality, and integrity. I'd like to address a number of key aspects going forward. First, we need to strongly support the ICC and oppose to any sanctions against them. The court needs our political support, as expressed by the presence of the numerous ministers and vice ministers here at the 24th session. But above all, they need our concrete support. It is specific, concrete measures that we can take that will enable the court to fulfill its mandate, particularly as concerns of funding, but also the tasks undertaken in order to find concrete solutions to concrete challenges. Secondly, we need to bolster the capacity of the court. The strength and independence of the court build on its independence, and we need to, as we expressed in the special session in July last, we wanted to bolster its jurisdiction when it comes to crimes of aggression. We furthermore need to work hand in hand to ensure further ratifications of the Rome Statute and for full ratification of its membership. Every new ratification counts for deepening the court's competence. Ministers and vice ministers here at the podium have talked about the importance of dialogue with non-states parties, and this is my third point. Switzerland is definitely in favor of dialogue. Dialogue is always better than sanctions. But this dialogue needs to be a true dialogue and not negotiations that try to undermine the fundamental principles on which the Court and the Rome Statute were built. And finally, the Court also needs to be concretely supported in terms of its capacity. And in this regard, Switzerland is proud to present Geniel Metro as a candidate to one of the judges' posts coming up in 2026. The experience, the integrity, and professionalism of Mr. Juge Metro are exemplary. And these are qualities that are required in this critical period for the Court. Madam President, Excellencies, ladies and gentlemen, ensuring that there is no impunity for the perpetrators of the world's gravest crimes is going to build a world peace, and those are the objectives that bring us together. The International Criminal Court is vital if we're going to reach these objectives. Let's remain united in supporting it as we strive for these objectives, ensuring its independence, integrity, and impartiality. Thank you very much.
I thank you for your statement and give floor to Austria, His Excellency Nikolaus Marschik, Deputy Minister of Foreign Affairs.
Thank you very much. Good afternoon, Madam President, distinguished delegates, ladies and gentlemen. As others before me, please let me start by thanking our hosts for welcoming us today in The Hague. I wish you, Madam President, every success for your work at the upcoming Assembly, and I thank the leadership and the team of the Court for the organization and preparation of this Assembly. Guided by the principle, no peace without justice, we are strong supporters of ensuring accountability and of standing united against impunity for international crimes against humanity. In my intervention, please let me share with you 3 short thoughts on the functioning of the Court, on the resolution of conflicts while safeguarding the international rules-based order, and on doubling our efforts to strengthen the rule of law. My first remark is on our joint commitment to support the functioning of the Court. Our meeting today clearly shows our determination, our commitment to support the functioning of the ICC. We are here to protect the integrity and independence of the Court now more than ever. We are all aware that the ICC, as well as its individual members, are under pressure, in particular from the outside. Consequently, we are committed to support the Court by increasing its resilience. After consultations, we understand that one element of resilience are sufficient financial resources. We will therefore front-load our payments. We will transfer our annual contribution for 26 already in the next weeks, and we will continue to support trust and special funds with additional voluntary contributions. At the same time, the Court must be 100% clear and transparent when it comes to challenges from the inside and allegations of misconduct. As goes for any institution, it is foremost in the Court's own interest to ensure full, swift, and comprehensive investigations and act upon the findings. My second remark is on the resolution of international conflicts and compliance with the Rome Statute. We live in a world of multiple armed conflicts and crisis situations. In times like these, we would argue that we need more respect and enforcement of the international rules-based order, and at the same time more international fora for negotiating pathways for fair and sustainable peaceful solutions. Some argue that we are facing a dilemma. Can you be a reliable state party of the Court that fully fulfills its obligations under the Rome Statute, and at the same time host in your country heads of state and government under ICC arrest warrants for ceasefire consultations or peace negotiations? In our understanding, you should be able to do both. And in our reading, you can. The Rome Statute offers the necessary tools and pathways, the consultation mechanism under Article 97, Article 98 regarding immunity and surrender, and Article 16 referring to UN security decisions in the interest of peace. In this spirit, we very much look forward to the discussions on cooperation as well as on non-cooperation during our conference. My third remark, doubling our efforts to strengthen the international rule of law architecture. Yes, the international rules-based order is under pressure. We hear this in many statements and speeches. Full respect for and commitment to the rule of law by all is a strong security guarantee, in particular for small and medium-sized countries like my own. Unfortunately, the current trend is going into another direction. Some countries are criticizing double standards. Some state parties are even considering leaving the ICC. And we read in the media that in current peace and ceasefire consultations, a general amnesty and impunity for war crimes are being discussed. In these circumstances, we should double our efforts and engage externally in dialogue, in particular with those states expressing concerns regarding the court and its principles, as well as engage internally in consultations among state parties with the aim of promoting the universality of the Rome Statute. And this is exactly why we are participating today in our conference. My final remark. For the longest time in our history, crimes against humanity were a brutal reality, including impunity in so many cases. Let us never forget. What we have achieved by adopting and ratifying the Rome Statute is a huge step forwards. So let us work hard, together, every day, to implement our principles into practice and to ensure that justice for all is no longer a vision, but a reality. Thank you very much.
I thank you for your remarks and give the floor to Lithuania, Her Excellency Audra Plepite, Vice Minister of Foreign Affairs.
Thank you, Madam President. Excellencies, distinguished delegates. While aligning with the statement made by Denmark on behalf of the European Union, I would like to address this Assembly in my national capacity. My Lithuanian delegation reaffirms its unwavering commitment to the International Criminal Court, to the Rome Statute system, and to the fundamental principles that underpin them, namely accountability of the perpetrators of the most serious crimes of international concern, justice for the victims, the overall advancement of the rule of law and justice. Our support is not only political. It also comes in the shape of voluntary financial contribution and delegation of investigator to the Office of the Prosecutor. Lithuania warmly congratulates Ukraine on becoming 125th state party to the Rome Statute and commends its swift implementation. On the other hand, it is highly regrettable that certain state parties, including the EU member states, have decided to withdraw from the statute. Today we meet at the moment marked by serious challenges to the court's work in the integrity of the statute. Recent developments expressed in the forms of sanction or threat to sanction directed to the ICC officials or even the court itself have caused serious concerns and raised the importance of safeguarding the court's integrity, independence, and impartiality, which we support. On the same time, some issues, including allegations of misconduct involving serious officials, have drawn public opinion. We are the opinion that must be handled with transparency, due process, and respect for institutional integrity, but also in a timely manner. If done so, we believe that may ultimately strengthen rather than weaken trust in the court. The court would function efficiently and ensure that perpetrators are brought to justice only if state parties fully observe their obligations, in particular the obligation to cooperate in arresting and surrender suspects sought by the court. It is extremely regrettable that this year was again marked by instances of non-cooperation and compliance by state parties, failure to arrest the indicted for the war crimes and sought by the court. Madam President, my delegation is fully committed to ensure that the court has the same jurisdiction regarding all types of international crimes, including the crime of aggression. Lithuania welcomes the outcome of the special session on the revision of the amendment on the crime of aggression, so we would have liked to achieve more concrete results in this regard. However, victims and survivors should be at the center of all efforts in pursuit of truth, justice, and accountability. They look upon the International Criminal Court as a beacon of hope and justice. Therefore, Lithuania calls on all state parties to follow the example of many, including my own country, to contribute with voluntary contribution to the Trust Fund for Victims, as it plays an essential role in ensuring that thousands of victims receive reparations and compensation. Madam President, I cannot fail to note the major development that has taken place in the area of international criminal law. It is the creation of the Special Tribunal for the crime of aggression against Ukraine under the auspices of the Council of Europe. Lithuania has completed all internal procedures and became the first full-fledged member of this tribunal. And we call upon other countries to speed up accession processes which would allow to launch this important tribunal. It would also send a clear message that the crime of aggression, a blunt violation of the most fundamental principle of international law, will entail true accountability. In conclusion, we wish to call all state parties to remain firmly and clearly committed to supporting the ICC as it remains an essential pillar of international rules-based order. It is up to us, the state parties, to stand ready to uphold its independence, integrity, and legitimacy in the service of justice and humanity. Thank you.
I thank you for your statement and give floor to Latvia, Her Excellency Lauma Kalna, Vice Minister, Minister of Justice.
Madam President, distinguished colleagues, ladies and gentlemen, it is an honor to address the Assembly of State Parties on behalf of Latvia. At the outset, Latvia expresses its appreciation to the President of the Assembly, the President of the International Court, of the International Criminal Court, the Prosecutor's Office, and the Court's personnel. We are thankful for the Court's tireless efforts in fulfilling its mandate under the Rome Statute, even in these difficult times the Court is facing. Madam President, Latvia aligns itself with the statement delivered on behalf of the European Union and wishes to add several remarks in its national capacity. We remain steadfast in our support for the independence and impartiality of the Court, its officials, and all those who contribute to the fulfillment to its judicial mandate. We condemn all attacks, cyber attacks, threats, and disinformation aimed to undermine the rules-based international order. The ICC must be able to work without fear and free from external pressure. The credibility, oh my God, that's such a word, of international justice depends on it. Ladies and gentlemen, over a decade has passed since the beginning of Russia's aggression against Ukraine, and almost 4 years since a full-scale invasion. The human toll continues to grow, and the severe and widespread violation of international law committed shake the very foundations of the global legal order. Accountability has never been more urgent. We encourage the Court to persist in its efforts to bring all perpetrators to justice. In this context, accountability for the crime of aggression is a fundamental part in ensuring international peace and security. Latvia welcomes the special session on the review of the amendments of the crime of aggression held in July of this year, and stresses that this discussion must not remain theoretical. The ICC still does not have jurisdiction over the crime of aggression. We must keep moving forward and harmonize the jurisdiction of the court. Latvia remains firmly committed to ending impunity for the gravest crimes of concern to the international community: war crimes, genocide, crimes against humanity, and the crime of aggression. Yet, this mission is not possible without the full and unconditional cooperation of all states parties. We therefore call upon all states to comply fully with their obligations under the Rome Statute, including financial contributions, arrest and surrender obligations, and cooperation in investigations and prosecutions. Madam President, ladies and gentlemen, the court is a cornerstone of international justice. Its strength lies not only in its legal mandate, but in its solidarity of its states parties. In that regard, Latvia congratulates Ukraine on becoming the 125th state party of the Rome Statute as of this year, and encourage Ukraine to ensure its swift implementation. In hindsight, it is regrettable that some states have announced their withdrawal from the Rome Statute. Turning away from the court does not serve justice, nor does it serve victims. We therefore encourage all states to reconsider such intentions and to remain with the Rome Statute system. Finally, Madam President and ladies and gentlemen, as state parties, we bear a collective responsibility to defend the Rome Statute and protect the values on which the court was founded. Latvia reaffirms its unwavering commitment to the fight against impunity and resolve to safeguard the integrity of the international rule of law. I thank you.
I thank you for a statement, and I give floor to South Africa, His Excellency Andreas Nel, Deputy Minister of Justice and Constitutional Development.
Madam President, South Africa thanks you for the opportunity to address this Assembly. We extend our warm congratulations and assurances of support to the newly elected officials of the court. South Africa reaffirms its steadfast commitment to the international rule of law, to justice, to accountability, and to the end of impunity. We also reaffirm in the words of the leader's statement of the recent G20 summit, hosted by South Africa for the first time on the African continent under the theme Solidarity, Equality, Sustainability. And I quote, "Our commitment to strengthening multilateralism with the UN at its core, rooted in the principles of international law as they are reflected in the Charter of the United Nations." Similarly, we reaffirm our commitment, in the words of the same statement, to quote, "to reform the Security Council through a transformative reform that aligns it with the realities and demands of the 21st century, makes it more representative, inclusive, efficient, effective, democratic, and accountable, and more transparent to the whole of the UN membership," close quote. As states parties, we must be unequivocal. The credibility and durability of the International Criminal Court depends on the consistent, impartial, and non-selective application of international law. Regrettably, the court continues to face unacceptable external pressures, including sanctions, cyber attacks, and even arrest warrants issued against its judges and officials. These actions not only attack the court, but also the interests of victims and the collective investment of states parties in international justice and the rule of law. They must be resolutely rejected. We commend the Registrar and the Government of the Netherlands as the host state for their efforts to safeguard the court's operations, and South Africa pledges its full support to these endeavours. However, political declarations of support, whilst necessary, are not sufficient. Concrete action is required. We urge all states parties to adopt the necessary domestic legislation and procedures to fully enable cooperation with the court. South Africa has initiated new legislation on extradition and on international cooperation in criminal matters, which explicitly provide for cooperation with the court and similar institutions. We're concerned by recent incidents of non-cooperation and call on states parties to make full use of the Rome Statute's consultation procedures to resolve any challenges that may arise. South Africa also strongly encourages states parties who have indicated their intention to withdraw from the Rome Statute to re-engage with the ICC community and to reconsider their decisions. These developments should galvanize our efforts towards universality of the Rome Statute system, a goal that remains indispensable to the fight against impunity. Ultimately, the pursuit of international criminal justice is and must remain centered on victims. We owe it to them to ensure meaningful participation in proceedings and to support the sustainable resourcing of the Trust Fund for Victims. Madam President, South Africa recognizes that the court's essential functions, investigations, prosecutions, witness protection, outreach, and more, require predictable and sustainable funding. At the same time, we acknowledge the economic pressures facing many states parties. We therefore appreciate the court's efforts to prioritize, make difficult adjustments, and present a budget that is both responsible and responsive to operational needs. We urge state parties to conclude the budget discussions swiftly, inclusively, and with flexibility. We also commend the court for the progress it has made in strengthening its internal workplace culture. While more work remains, it is encouraging to see efforts aimed at ensuring that the court's internal environment fully reflects the Rome Statute's values of fairness, accountability, and justice. Madam President, South Africa continues to value the indispensable role of civil society in promoting justice, accountability, and the rule of law. Civil society has been integral to the Rome Statute system from the beginning, and we call on all states parties to deepen engagement and forge stronger cooperative partnerships with civil society organizations. South Africa remains dedicated to strengthening the integrity, independence, and effectiveness of the court and the office of the prosecutor so that they may deliver justice impartially and without hindrance. And therefore, in the words of President Nelson Mandela, and I quote, "We have sought to ensure that the ICC is guaranteed independence and bestowed with adequate powers. Our own continent has suffered enough horrors emanating from the inhumanity of human beings towards human beings. Who knows, maybe many of these might not have occurred, or at least been minimized, had there been an effectively functioning international court." Close quote. We thank you.
I thank you for your statement and give floor to Romania, His Excellency Luca Niculescu, Secretary of State, Ministry of Foreign Affairs.
Madame la Présidente,
Madam President of the Assembly of States Parties, Excellencies, dear distinguished delegates, ladies and gentlemen, first of all, thank you for the invitation and for the organization of this seance. Romania would like to align itself with the EU statement made on behalf of all of the member states and would like to make a few additional remarks in a national capacity. Today, more than ever, it's important for us to remember why the ICC was created, to respond to this universal need for justice and for the victims of atrocities. And the best, I think, starting point for today would be from the preamble of the Rome Statute itself, mindful that during this century, millions of children, women, and men have been victims of unimaginable atrocities that deeply shock the conscience of humanity. Unquote. The ICC has become a central pillar of the international criminal justice system, and its role is vital for promoting an international order based on the rule of law, so as to fight against impunity for the perpetrators of the most heinous crimes and offer justice to victims. Romania would like to recall its firm commitment to the court ever since its creation and reiterates its unwavering and firm support for the ICC in its struggle against impunity. Today, that collective ideal of justice, as established by the Rome Statute, is in danger. In the last year, the ICC has had to face various different challenges: political pressure, sanctions, the erosion of cooperation, and the weakening of the principle of universality, as well as new incidents of cyber attacks. We mean that we need to support the court more than ever. It's up to us to lend our continued support to the court's work because this is the responsibility that is incumbent upon us. And the court can only work with our cooperation as per the Rome Statute of the ICC. Supporting the court means supporting victims and confirming that impunity will not be tolerated. As of the 1st of January 2025, Ukraine became the 125th state party to the Roma Statute, and we congratulate Ukraine on this achievement. At the same time, we regret the announcement of withdrawals of the Roma Statute. Universality is our shared objective, despite temporary setbacks that we are facing. Over and above these external challenges, the court is now confronted with internal challenges. The allegations of misconduct need to be the subject of an in-depth investigation and be treated in a transparent and rapid manner. And the court, despite these challenges, has shown remarkable adaptation and resilience and needs to continue affirming its mandate in compliance with the Rome Statute. By persevering in its mission, it recalls that impunity for the most serious international crimes and the protection of victims are at their heart, and above all, in a period of turbulence like this, of international justice. The court can count on Romania's strong support and which stands ready to discuss and examine modalities enabling to strengthen the court's resilience. Thank you very much, Madam President.
I thank you for your statement and give floor to Georgia, His Excellency Georgi Gebuadze, Deputy Minister of Justice.
Thank you. Madam President, Excellencies, distinguished delegates, ladies and gentlemen. Georgia expresses appreciation for convening the 24th session of the Assembly of State Parties. We thank the Assembly and the organs of the Court for their dedicated work throughout the past year and acknowledge the steady efforts made to reinforce cooperation, support victims, and advance the effective implementation of the Court's mandate. The delegation reaffirms full support to the Court as an impartial and independent judicial institution and stresses the importance of safeguarding the integrity and effectiveness of the Rome Statute system, so that the mandate of the Court is carried out with credibility and with the confidence of state parties and affected communities. We are proud to stand among the founding state parties to the Rome Statute and to reaffirm our unwavering commitment to the principles and purposes that underpin the Rome Statute system. The delegation recalls that the situation in Georgia presents a clear demonstration of the mandate entrusted to the Court. The investigation represented the ICC's first engagement on the territory of a European state party and first examination of alleged crimes arising from an international armed conflict. The significance of this development reaches far beyond our region. The experience confirms the global reach of the Court's jurisdiction and reinforces the expectation that accountability must be pursued in a principled and impartial manner, regardless of geography, regardless the identity and alleged perpetrators or any political consideration. In this context, we have maintained full and continuous cooperation with the Office of the Prosecutor, providing comprehensive assistance to support a fair, transparent, and effective investigative process. This cooperation led to the issuance of arrest warrants for 3 individuals who had committed crimes against the population of Georgia. For us, effective execution of the Court's arrest warrants remain a central test of the international community's commitment to justice and the rule of law. Genuine progress on enforcement is essential to secure long-awaited justice for the victims of the 2008 armed conflict and to reaffirm that accountability for the gravest crimes is a shared responsibility that sustains the credibility, unity, and purpose of the Rome Statute system. In this regard, Georgia further refers the landmark judgment of the European Court of Human Rights of the 14th of October 2025 on the case of Georgia versus Russia. The court held Russia fully responsible for the mass harassment, unlawful detention, physical attacks, killings, and the official tolerance of such actions against the population of Georgia in the occupied territories and along the occupation line. These violations occurred in the context of the ongoing occupation of the territories of Georgia and the process of the so-called borderization. We would like to reaffirm that full, timely, and good faith cooperation is essential to the effective functioning of the Rome Statute system, and we remain committed to meeting all cooperation obligations and in conformity with the statute. The delegation notes our steady and constructive engagement with all structures of the Court, including the provision of prompt and coordinated responses to requests for information and assistance through established national mechanisms. We continue to consolidate national cooperation arrangements through clear procedures, coordinated action, and strengthened institutional capacities, reflecting our firm conviction that consistent and reliable cooperation by all state parties is essential of safeguarding the authority of the court and sustaining confidence in the Rome Statute system. In closing, we reaffirm our deep commitment to the International Criminal Court and to the pursuit of accountability for the most serious crimes committed against the population of Georgia. There remains a clear and well-founded expectation among the people of Georgia and the wider international community that the court's arrest warrants will be executed without delay so that the victims of the August 2008 armed conflict receive the justice they have awaited with peace and dignity. In this regard, we will continue to work closely and constructively with the court toward this objective and encourage all state parties to strengthen cooperation and coordinated action in support of effective implementation of the court's mandate, which is essential to maintaining confidence in the Rome Statute system. The delegation of Georgia expresses sincere appreciation to Madam President and entire ASP team for their dedicated work and extends its best wishes for a successful session and for continued progress in the period ahead. Thank you.
I thank you for your statement and give floor to Ireland, Her Excellency Anne Derwin, Ambassador, Kingdom of the Netherlands.
Madam President, Ireland associates itself with the statement made by Denmark on behalf of the European Union. Allow me to begin by thanking you, Madam President, as well as the officials of the ICC for your tireless efforts on behalf of the Court this year. I can assure you that Ireland remains a staunch supporter of both your work and the wider Rome Statute system. The world has never been more in need of the ICC's mandate to end impunity. Sadly, the ICC has also never faced greater external pressure due to the escalating level of threats and attacks directed against it. We are deeply concerned by the sanctions imposed by the US against court officials and those cooperating with it. We also condemn the recent cyber attacks against the ICC and the criminal proceedings against its judges instituted by Russia. All of us as state parties are the custodians of the ICC. Attacks against the court are attacks on the values that we collectively cherish: justice, accountability, and the rule of law. It is therefore incumbent upon each and every one of us to support the court in its time of need. We therefore welcome the opportunity provided by this year's thematic debate to discuss measures to protect and strengthen the court. I will now highlight what elements Ireland believes can contribute to this endeavour. Madam President, political support for the court is the bedrock on which all efforts to defend it must be built. In that vein, Ireland was honoured to host a visit of President Akane in July of this year, during which we reaffirmed our steadfast commitment to the ICC. Good faith cooperation by states parties in the investigation and prosecution of those responsible for international crimes is another necessary element. Ireland notes with regret the recent findings of non-cooperation delivered by the pre-trial chamber and urge all state parties to renew their commitment to assisting the court in line with their obligations under the Rome Statute. Sufficient financial resources are needed if the court is to have the strength to overcome its present challenges. In particular, we note the need to replenish the court's contingency fund. We welcome the recommendations of the Committee on Budget and Finance as a suitable basis to achieve this. We also commend the efforts that the court has made in moderating its proposed programme budget for next year. A healthy workplace environment is essential both for the well-being of staff and their ability to pursue justice on behalf of victims. It is important that we foster an institution where everyone is respected and no one is above the rules. While we welcome efforts in the Hague Working Group this year to improve internal accountability at the Court, it is clear that further improvements to the Court's working environment are required. Finally, we must enhance the resilience of the Court if it is to have the strength to withstand external attacks. Reliable service providers are needed to continue to engage with the ICC in spite of coercive measures. We acknowledge the impressive efforts of court officials, especially the Registrar, in improving business continuity. Madam President, despite the formidable array of challenges faced, the ICC must be commended for continuing to progress its work. It has been a notable year for judicial developments. Amongst other achievements, we have seen 2 trial judgments, including the first in a situation referred by the UN Security Council, as well as the first conviction for gender persecution. These milestones demonstrate the continued relevance of the ICC in delivering justice for victims. Ireland also notes the progress that the Court has made in progressing its reparations mandate, with a record number of reparation programmes delivered restorative justice to affected individuals and communities. We hope that the first completion of a reparations programme in the Katanga case helps victims rebuild their lives with dignity. We recognise the invaluable contribution of the Trust Fund for Victims in delivering court-awarded reparations. As a regular contributor to the Trust Fund, we urge state parties to consider supporting its work, especially in the light of its increasing need to meet the demands of victims. Madam President, this year we also welcomed Ukraine as a new state party to the Rome Statute, highlighting the continuing significance of the Court in an increasingly fractured world. We deeply regret any indications of an intent to withdraw, and we strongly encourage states concerned to engage with partners, including at this week's Assembly. Finally, Madam President, as we contemplate the current challenges facing the Court, we should take heart from what we have achieved thus far. If the drafters of the Rome Statute could overcome seemingly intractable obstacles to establish the first permanent international tribunal to try perpetrators of unimaginable crimes without fear or favour, then surely we can too unite to protect their legacy. Thank you, Madam President.
I thank you for your statement, and that brings us to the end of the list of speakers under the general debate tonight. I would like to thank all the distinguished speakers today for their statements and the support pledged to the Court in the fulfillment of its mandate, and also to the kind words addressed to me and to the Secretariat. Tomorrow we will continue the general debate with speakers that were not able to speak today, and we will start first with Poland, to be followed by Senegal and Canada. I would note that Venezuela has requested a right of reply, and normally it is delivered during the same day, so I would give the floor to Venezuela, and of course remind that we have spoken on that topic and just remind that taking the late hour, well, it would be short, or whether you would. We seem to have some problem with the computer. It's not. Oh, now it's good. Now it works. Venezuela, you have the floor.
Thank you, Madam President. Well, in fact, I know that you like very much my voice, but we haven't requested any right of reply. So thank you in any case for your kind possibility, but we haven't required anything for today. So have a nice evening. Thank you.
Thank you very much. That was good news. There has been some misinterpretation in the line of delivering messages, but that is indeed good news to us, since that brings us to the end of today's discussions. I thank the interpreters for the long day, and I would like to remind distinguished ministers and deputy vice ministers that there is a bus at the main entrance of the World Forum for the visit to the ICC premises with the elected officials of the court as per ministerial program. And we would request the ministers to gather 6:05 at the registration area, which is at the entrance, and for the bus departure that will take place 6:15 p.m. And I assume that there are no more requests for the floor, so the meeting is adjourned.